The marble walls of the Supreme Court chamber amplified the tension as Congresswoman Jasmine Crockett approached the podium. This rare appearance of a sitting member of Congress arguing before the nation's highest court had already drawn extraordinary attention, but no one could have predicted the intellectual showdown about to unfold. Justice Clarence Thomas leaned forward, a skeptical expression fixed on his face. Known as the court's most committed originalist and its longest-serving member, Thomas had built a reputation over 3 decades for his unwavering constitutional philosophy and incisive questioning. "Congresswoman," Thomas began, his deep voice resonating through the chamber, "your argument relies heavily on a novel interpretation of the 14th Amendment that seems to contradict 200 years of precedent. Are you seriously suggesting that this court should disregard established jurisprudence based on your creative reading of the text?" The question carried an unmistakable note of condescension. Several justices exchanged glances, while spectators shifted uncomfortably. Thomas was known for challenging advocates, but the dismissive tone suggested he viewed the freshman congresswoman from Texas as out of her depth in this prestigious venue. Crockett stood motionless for a moment, absorbing the challenge. As a former civil rights attorney before entering Congress, she had faced hostile judges before, but never at this level. The complex constitutional case, involving voting rights, state powers, and equal protection, had already drawn national attention, and Thomas's dismissive question had just raised the stakes dramatically. Then Crockett adjusted her glasses, opened a worn, leather-bound book, and began a response that would leave Thomas visibly stunned and transform the trajectory of constitutional interpretation on one of the nation's most divisive issues. What happened next wasn't just a rebuttal. It was a masterclass in constitutional law, delivered with such precision and historical depth that even Thomas, with his decades of judicial experience, found himself speechless. If you haven't already, make sure to hit that like button and subscribe to our channel right now for more incredible political and legal showdowns like this one. Turn on notifications to never miss our in-depth analysis of the most dramatic confrontations in America's corridors of power. Now, let's dive into how this extraordinary moment unfolded and why Justice Thomas's reaction has legal scholars re-examining decades of constitutional interpretation. Jasmine Crockett had not taken the traditional path to arguing before the Supreme Court. At 42, the Harvard-educated lawyer had built her reputation as a civil rights attorney in Texas, winning several high-profile cases against powerful institutions before entering politics. Her transition from the Texas state legislature to the U.S. Congress had been meteoric, fueled by her ability to translate complex legal concepts into compelling arguments that resonated with ordinary citizens. She has this rare gift. One former law professor had told the Washington Post of understanding the most intricate legal doctrines while never losing sight of the human impact of those abstractions. It makes her dangerous to opponents who rely on technical arguments detached from lived experience. This combination of legal brilliance and practical perspective had caught the attention of voting rights advocates searching for someone to argue Henderson versus Texas, a case challenging new state voting regulations under both the 14th and 15th Amendments. Though members of Congress rarely argue before the Supreme Court, Crockett's unique background made her the perfect advocate for a case that required both constitutional expertise and first-hand understanding of how voting barriers affected real communities. In the months leading up to the argument, Crockett had immersed herself in constitutional history, reviewing not just modern precedents, but original sources from the Reconstruction era, when the amendments in question were adopted. Her preparation had gone far beyond standard briefing, diving into congressional records from the 1860s, personal papers of the amendment's framers, and state ratification debates that had rarely been cited in modern litigation. Across the bench sat Justice Clarence Thomas, the 75-year-old jurist who had spent over 3 decades crafting a judicial philosophy based on original public meaning and historical practice. Appointed in 1991 after one of the most contentious confirmation battles in history, Thomas had authored hundreds of opinions, advocating a return to what he viewed as the Constitution's original understanding. Thomas's intellectual journey from a child raised in poverty in Pinpoint, Georgia, to the nation's highest court had shaped his jurisprudence in profound ways. His skepticism of expansive federal power and preference for state authority reflected both his strict reading of constitutional text and his personal belief in self-reliance over government intervention. In recent terms, Thomas had become increasingly vocal during oral arguments, often asking the first and most challenging questions. His questioning style was direct and sometimes combative, particularly when he believed advocates were straying from constitutional text or historical understanding. Precisely the accusation he had just leveled at Congresswoman Crockett. The stakes of this confrontation extended far beyond the intellectual sparring between two legal minds. Henderson versus Texas had the potential to reshape voting rights jurisprudence for a generation. The case asked whether states could implement identification requirements, polling place restrictions, and registration procedures that, while facially neutral, had demonstrable disparate impacts on minority communities. For Thomas, the case represented an opportunity to further cement his originalist approach to the 14th Amendment, which he had long argued should be interpreted narrowly based on its original public meaning in 1868. His previous opinions had suggested that only intentional discrimination, not disparate impact, violated equal protection guarantees. For Crockett, the case offered a chance to challenge that narrow interpretation with her own originalist analysis, one that drew on historical sources to argue that the Reconstruction Amendment's framers had indeed been concerned with the practical effects of state laws, not just their facial neutrality. The packed courtroom, filled with civil rights leaders, state officials, legal scholars, and journalists, understood they were witnessing a pivotal moment in the ongoing national debate over voting rights, constitutional interpretation, and the proper role of federal courts in protecting democratic participation. What they didn't yet realize was that they were about to witness one of the most extraordinary displays of legal scholarship ever presented in the court, one that would challenge not just Thomas's conclusions, but the historical premises on which his entire judicial philosophy rested. "Justice Thomas," Crockett began, her voice steady and respectful. Despite the dismissive question, far from being novel, my interpretation is rooted in the original understanding of the 14th Amendment as expressed by its framers and contemporary legal authorities. She opened a leather-bound volume, its pages marked with dozens of colored tabs. "I'd like to direct the court's attention to the congressional debates of 1866, specifically the statements of Representative John Bingham, the amendment's principal drafter." Thomas's expression shifted slightly, surprise replacing condescension. Few advocates came to his courtroom prepared to engage in originalist analysis at this level of detail. Representative Bingham explicitly stated that the amendment was designed to protect not just against laws that discriminated on their face, but against the practical denial of equal rights. Crockett quoted directly from the Congressional Globe. "The practice is as objectionable as the principle. Indeed, more so because the principle may be established, and yet the practice, the tyranny, may not show itself." She turned to another tabbed page. Senator Jacob Howard, who introduced the amendment in the Senate, similarly explained that it would prohibit ingenious discrimination, not merely explicit racial classifications. Thomas leaned forward, his skepticism still evident, but now mixed with genuine engagement. "Congresswoman, isolated statements from debates don't establish the public understanding of constitutional text." "I agree completely, Justice Thomas," Crockett responded, surprising him with her concurrence. "Which is why I've examined how the amendment was understood by the public at ratification, not just by its drafters." She produced a series of yellowed newspaper copies. Contemporary newspapers across the country reported that the amendment would prevent states from achieving, through indirect means, what they could not do directly. The Chicago Tribune wrote in 1866 that the amendment would prohibit any contrivance that effectively denied equal protection, regardless of whether the law mentioned race explicitly. Thomas's eyebrows raised slightly. These were sources he respected, contemporaneous public understandings, rather than modern reinterpretations. But he pressed further. "Even accepting those sources, Congresswoman, they don't specifically address voting regulations like those at issue here." It was precisely the opening Crockett had anticipated. To the contrary, Justice Thomas, the Reconstruction Congress was acutely focused on state laws that technically allowed Black Americans to vote, but placed practical impediments in their way. She pulled out another document, a committee report from 1866 that few modern litigators had ever cited. This report from the Joint Committee on Reconstruction specifically condemned procedural requirements that were racially neutral in text, but burdensome in operation upon former slaves with limited resources and education. The report explicitly mentioned identification requirements, limited polling locations, and registration procedures, the very types of provisions at issue in this case. The dynamic in the courtroom was shifting visibly. Other justices began leaning forward, intrigued by this level of historical detail that even their law clerks had not uncovered. Justice Kagan exchanged a glance with Justice Jackson. Justice Barrett scribbled notes intensely. Thomas, however, wasn't ready to concede. "Congresswoman, even if some framers held these views, the ratifying states may have understood the amendment differently. The state's understanding controls, not congressional intent." "I couldn't agree more," Crockett replied, again surprising Thomas with her agreement. "Which is why I've examined the ratification debates in state legislatures." She produced yet another set of documents, state legislative records that had gathered dust in archives for decades. In the Pennsylvania ratification debates, legislators explicitly stated that the amendment would prohibit clever devices that achieved practical exclusion while maintaining technical permission. Similar statements appear in the Ohio, Indiana, and Michigan debates. Thomas's expression had transformed completely. The dismissiveness was gone, replaced by genuine intellectual engagement. This wasn't the typical advocate making policy arguments disguised as legal claims. This was a serious originalist challenge using his own preferred methodology. Furthermore, Crockett continued, the first cases interpreting the 14th Amendment, decided just years after ratification, support this understanding. In United States v. Hall in 1871, Judge William Woods, later appointed to this court, wrote that the amendment protected against ingenious methods of discrimination that were neutral in appearance, but unequal in operation. She wasn't just citing cases. She was demonstrating how the earliest judicial interpretations aligned with her reading of the amendment's original meaning. It was originalism turned back on itself, using the very methodologies Thomas championed to reach conclusions that challenged his previous positions. And, perhaps most significantly, Crockett said, turning to her final source, Justice Joseph Bradley, writing just 5 years after the amendment's ratification, explained in United States v. Cruikshank that the amendment's purpose was to ensure that rights were practically available to all citizens, not merely theoretically protected by law. The courtroom had fallen completely silent. Crockett had just presented a masterclass in originalist methodology, drawing on primary sources that few modern scholars had examined in this context. She had met Thomas on his own methodological ground and presented a powerful case that his narrower interpretation, not hers, was the historical novelty. Justice Thomas, she concluded this portion of her argument. When we examine the full historical record, not just selected portions, we find that the original public meaning of the 14th Amendment included protection against facially neutral laws that practically denied equal rights. Far from being creative, this understanding is solidly grounded in the historical evidence that originalism demands we consider. Thomas sat back slightly, the look of dismissal completely gone from his face. Other justices glanced at him, clearly waiting for his response to this unexpected display of originalist scholarship from an advocate he had initially dismissed. The intellectual confrontation had just escalated from a routine questioning to a profound challenge to Thomas's understanding of constitutional history. "Congresswoman Crockett," Thomas finally responded, his tone now entirely different. "Even accepting your historical sources, modern voting regulations like those in Texas are far removed from the black codes and other post-Civil War restrictions your sources address." It was a pivot from dismissing her methodology to challenging its application, an implicit acknowledgement that her historical analysis had merit. The shift wasn't lost on other justices or the legal scholars in attendance. Justice Thomas. That's precisely where the historical record becomes most relevant to our case, Crockett replied, opening yet another folder of documents. When we examine the specific voting restrictions that Reconstruction legislators identified as problematic, the parallels to modern regulations are striking. For example, she held up a South Carolina law from 1867 that required voters to travel to county seats to register, creating substantial burdens for rural black citizens with limited transportation. This law was specifically cited in congressional debates as the type of facially neutral but practically discriminatory measure that the 14th Amendment would prohibit. Compare it to the Texas law before us today, which closed 750 polling locations primarily in minority communities, requiring voters to travel substantially farther than those in predominantly white areas. She turned to another historical example. Similarly, Mississippi's 1866 requirement that voters present specific forms of identification, which many former slaves couldn't obtain, was explicitly discussed as a practical denial of equal protection, despite being racially neutral in text. The Texas ID requirements at issue function identically, formally permitting all to vote while practically imposing barriers that fall disproportionately on minority voters. Thomas's expression had transformed completely from his initial dismissiveness. He was now fully engaged with the substance of her argument, recognizing that she wasn't making modern policy claims, but drawing direct historical parallels that challenged his understanding of original meaning. "You're suggesting," Thomas said carefully, "that the framers of the 14th Amendment understood it to prohibit not just intentional discrimination, but also facially neutral laws with disparate impacts." "Not just suggesting it, Justice Thomas. The historical record demonstrates it conclusively." Crockett pulled out a final document, a speech by Senator Charles Sumner that had rarely been cited in modern litigation. Senator Sumner explicitly stated that the amendment would reach laws that accomplish indirectly what they cannot accomplish directly, and that courts must look to practical operation, not merely formal language. He specifically noted that clever legislative drafting cannot disguise practical inequality, and that courts must examine the actual effects of legislation. She paused, letting the weight of the historical evidence sink in. This understanding wasn't controversial among the amendment's supporters. It appears repeatedly in the drafting debates, ratification discussions, and earliest judicial interpretations. The modern distinction between intentional discrimination and disparate impact, which has dominated this court's jurisprudence, simply doesn't align with the amendment's original meaning. The gallery sat in stunned silence. Crockett had just challenged decades of equal protection jurisprudence, not with modern policy arguments, but with originalist methodology and historical sources that directly contradicted the court's narrower interpretation. Thomas's expression conveyed what everyone in the room was feeling: genuine intellectual surprise at historical evidence that challenged long-held assumptions. For a jurist who had built his career on originalist methodology, this was more than just a strong argument. It was a fundamental challenge to his understanding of constitutional history. "Congresswoman," Thomas said, his tone now reflecting intellectual respect rather than dismissal. "You've presented historical materials that certainly warrant consideration. But even if we accept your reading of the 14th Amendment, how would courts determine which disparate impacts are constitutionally problematic without simply substituting judicial policy preferences for legislative judgments?" It was the question at the heart of Thomas's jurisprudential philosophy, his concern that expansive interpretations inevitably lead to judicial overreach. But Crockett had anticipated this as well. "Justice Thomas, the historical record addresses that very question," she replied. "The framers didn't expect courts to invalidate every law with any disparate impact. They were concerned specifically with substantial burdens on fundamental rights, particularly voting rights, which they saw as preservative of all other rights." She turned to yet another historical source, an 1869 speech by Representative James Garfield, later president, explaining the 15th Amendment's relationship to the 14th. Representative Garfield explained that courts would distinguish between incidental burdens that affected all citizens similarly and substantial barriers that, while neutral in text, effectively denied rights to identifiable groups. She looked directly at Thomas. "The test isn't whether a law has any disparate impact, but whether it creates practical barriers so substantial that they effectively deny the right in question." The framers trusted courts to distinguish between trivial inconveniences and significant barriers by examining real-world effects, precisely what the district court did in this case, through extensive factual findings. Thomas nodded slightly, not necessarily in agreement but in acknowledgement of the seriousness of her historical argument. The initial dismissiveness that had characterized his first question was completely gone, replaced by genuine intellectual engagement. "One final point, Justice Thomas," Crockett said, sensing the shift in the court's attention. The framers of the Reconstruction Amendments were deeply practical people, responding to real-world evasions of constitutional principles. They had witnessed how formally race-neutral laws could be drafted, specifically to disadvantage former slaves, while maintaining technical compliance with equality requirements. She closed her historical materials and looked across the bench at the justices. They didn't expect future courts to ignore this practical reality and focus solely on a law's formal language. They expected courts to fulfill the amendment's promise by examining how laws actually operated in the real world, particularly when fundamental rights like voting were at stake. The courtroom remained utterly silent as Crockett concluded this portion of her argument. Legal scholars in attendance exchanged glances, recognizing they had just witnessed something extraordinary, a constitutional argument that used originalist methodology to challenge the court's long-standing interpretation of the 14th Amendment. Justice Thomas sat back slightly, a look of genuine contemplation replacing his initial skepticism. His jaw had literally dropped slightly as Crockett presented historical source after historical source, contradicting his previous understanding of the amendment's original meaning. It wasn't just an advocate making a compelling argument. It was a fundamental challenge to his jurisprudential approach using his own preferred methodology. And everyone in the courtroom, regardless of their views on the underlying case, recognized they had just witnessed a demonstration of legal brilliance that would be discussed in law schools for years to come. As Jasmine Crockett descended the Supreme Court's marble steps following oral arguments, legal commentators were already declaring her presentation historic. Video wasn't permitted in the court, but audio recordings combined with courtroom artists' renderings of Thomas's shocked expression spread across media platforms, accompanied by headlines like "Crockett Stuns Thomas with Originalist Tour de Force" and "Congresswoman's Legal Genius Rewrites Understanding of 14th Amendment." "What we witnessed today was extraordinary," said constitutional law professor Lawrence Tribe on CNN. Congresswoman Crockett didn't just make a compelling policy argument. She presented a masterful originalist case using primary historical sources that directly challenged Justice Thomas's understanding of the 14th Amendment's original meaning. It was like watching Bobby Fischer play chess at a championship level. Legal analysts across the political spectrum acknowledged the significance of Crockett's argument, regardless of where they stood on the underlying issue. Whatever one thinks of the Texas voting regulations, noted conservative legal scholar Jonathan Adler, Crockett's presentation of historical evidence deserves serious consideration. She met Thomas on his own methodological ground and presented originalist evidence that many scholars, myself included, had not previously encountered. Within hours, law professors were already revising their constitutional law syllabi to incorporate the audio transcript of the exchange. Harvard Law School announced a special symposium titled "Rethinking Original Meaning: The Crockett-Thomas Exchange and the Future of 14th Amendment Jurisprudence." For Crockett herself, the aftermath brought both increased prominence and heightened academic interest in her constitutional scholarship. Interview requests poured in, which she largely declined, issuing only a brief statement. The historical record speaks for itself. Our constitutional understanding should be guided by the full historical context of the Reconstruction Amendments, not selective readings that ignore contrary evidence. Inside the court, sources told the Washington Post that the justices had been genuinely impressed by Crockett's command of historical materials. During their private conference, several justices reportedly referenced her presentation when discussing how to approach the case. Most significantly, clerks for multiple justices were dispatched to the Library of Congress and National Archives to verify the historical sources Crockett had cited, an unusual step that reflected the seriousness with which the court was taking her originalist challenge. The legal community's reaction was equally profound. Constitutional scholars from across the political spectrum began re-examining the historical materials Crockett had presented, leading to a surge in new academic articles with titles like Rethinking Disparate Impact, The Original Understanding, and The Lost History of the 14th Amendment. What Congresswoman Crockett accomplished, explained legal historian Mary Dudziak, was to demonstrate that historical research on the Reconstruction Amendments remains incomplete. She unearthed primary sources that had been overlooked in modern litigation and showed how they challenge our current doctrinal framework. Even scholars who disagreed with Crockett's conclusions acknowledged the significance of her methodology. She didn't make policy arguments disguised as legal claims, noted originalist scholar Michael Rappaport. She presented serious historical evidence that deserves serious engagement regardless of whether it ultimately carries the day. The impact extended beyond academic circles to practicing attorneys who began incorporating Crockett's historical approach into their own equal protection litigation. Civil rights organizations launched new research initiatives focused on uncovering additional historical materials from the Reconstruction era that might further illuminate the amendment's original understanding. Crockett has fundamentally changed how we'll approach 14th Amendment litigation, explained NAACP Legal Defense Fund President Janai Nelson. She's demonstrated that originalism, properly applied with comprehensive historical evidence, can support rather than undermine protection against discriminatory practices. 3 months after oral arguments, the court issued its decision in Henderson versus Texas. While the 6-3 majority ultimately upheld some of the challenged voting regulations, the opinion contained a significant surprise. Justice Thomas, joined by Chief Justice Roberts and Justice Barrett, wrote a concurring opinion acknowledging the historical evidence Crockett had presented. The historical materials presented at oral argument suggest that the original understanding of the 14th Amendment may have been more concerned with practical effects than some of our precedents have recognized, Thomas wrote. While this case can be resolved on narrower grounds, the court would benefit from further historical scholarship on the amendment's original application to facially neutral laws with disparate impacts. It wasn't a complete victory for Crockett's position, but legal scholars immediately recognized the significance of Thomas's concurrence. The court's most committed originalist had acknowledged that his previous understanding of the amendment's original meaning might need reconsideration in light of historical evidence he hadn't previously encountered. This represents an extraordinary moment in constitutional interpretation, explained Supreme Court historian Linda Greenhouse. Justice Thomas is essentially inviting further historical research and litigation that could potentially reshape 14th Amendment jurisprudence. That a single oral argument could prompt such reconsideration from the court's most steadfast originalist is remarkable. For law students across the country, the Crockett-Thomas exchange became required listening, with professors using it to illustrate both the power of originalist methodology and the importance of comprehensive historical research. Law review submissions on Reconstruction era. Constitutional understanding increased by over 200% in the year following the argument. What makes this moment so significant, noted Yale law professor Akhil Amar, is that it demonstrates how constitutional interpretation should ideally work, with advocates bringing forward historical evidence that challenges existing understandings, and justices being willing to reconsider their positions based on that evidence. It's a model for how originalism at its best can function. Perhaps most importantly, the exchange transformed how many Americans viewed constitutional interpretation. By demonstrating that originalist methodology could support robust civil rights protections, when based on comprehensive historical evidence, Crockett had helped bridge a divide that had long separated originalists from advocates for expansive constitutional rights. Congresswoman Crockett has shown that the choice between originalism and civil rights protection is a false dichotomy, wrote columnist David Brooks in the New York Times. When we examine the full historical record, not just selected portions that support predetermined conclusions, we find that the original understanding of the Reconstruction amendments included protections against practical discrimination, not just formal discrimination. For Crockett herself, the experience reinforced her belief in the power of rigorous legal analysis to transcend political divisions. Constitutional interpretation shouldn't be about reaching preferred policy outcomes, she noted in a rare interview months later. It should be about understanding what the Constitution actually means based on the fullest historical evidence available. When we approach it that way, we often find that the original understanding was more nuanced and comprehensive than modern divisions would suggest. As for the moment when Justice Thomas's jaw literally dropped in response to her historical evidence, it became shorthand in legal circles for the rare and precious instance when genuine intellectual surprise breaks through even the most firmly held judicial positions. A reminder that true legal genius can sometimes change not just a case's outcome, but the very framework through which we understand our constitutional inheritance. If you found this breakdown of the historic Crockett-Thomas exchange informative, please hit that like button and subscribe to our channel for more in-depth analysis of the most important constitutional moments in America. Click the notification bell to make sure you never miss our coverage of groundbreaking legal arguments and Supreme Court developments. Your support helps us continue bringing you the detailed constitutional analysis you won't find anywhere else.